Has a contractor completely ripped you off? Or maybe a friend just flat out refused to pay back a loan? Look, that feeling of helplessness is incredibly frustrating, especially when you figure, hiring a lawyer is just going to cost way more than you're even owed in the first place. But here's the empowering truth. You absolutely do not have to just let it slide. You can navigate the legal system entirely on your own and get your money back, literally without paying a single dime for a lawyer.
It's a super common misconception that walking into a courthouse requires a law degree or some massive retainer fee. In this explainer, we're going to show you exactly how the Ohio Small Claims Court was built specifically for complete beginners. It was designed from the ground up to be accessible, affordable, and totally straightforward, so everyday citizens like you and me can resolve disputes on our own.
Okay, let's dive into this. Here is our step-by-step roadmap for today. We're going to demystify this whole intimidating legal process by breaking it down into 5 really manageable phases. First, basics and eligibility requirements. Second, preparing your evidence. Third, filing and serving process. Fourth, attending your court hearing. And finally, post-hearing judgments and appeals.
All right, let's jump right into Section 1, Basics and Eligibility Requirements. Because before we even think about filling out any court forms, we absolutely need to understand the rules of the playing field.
So, the very first thing you need to know is the monetary limit. The absolute maximum amount you can sue for in an Ohio Municipal Court's Small Claims Division is $6,000. Now, if you happen to live in a more rural area handled by a county court, that limit drops down to $3,000. And it's really important to note that this cap strictly excludes interest and court costs. So if someone owes you, say, $7,000, well, you have a choice. You can either waive that extra $1,000 to keep the awesome simplicity of small claims court, or you have to file in the regular civil division, which is honestly way more complex and almost always requires an attorney.
Next up, we really need to look at what types of cases actually qualify here. Small claims courts in Ohio are strictly for money-only disputes. That means a magistrate can order someone to pay you for a botched contractor job, an unreturned security deposit, or a fender bender. But they absolutely cannot force a mechanic to actually fix your car. They can't order someone to return a specific piece of property to you, and there is no way they can award you money for emotional distress, pain and suffering, or slander. This is all about actual, calculable monetary damages only. Venue rules are also incredibly strict, and this brilliantly illustrates a key point. You can't just file your lawsuit at whatever courthouse happens to be closest to your house. By law, you must file your claim in the specific local court where the defendant actually resides, where their business is located, or exactly where the incident occurred. If you file in the wrong jurisdiction, your case is just going to get dismissed, and you'll completely lose your filing fee. Moving right along to Section 2, preparing your evidence. And I literally cannot stress this enough. Winning your case depends almost entirely on how well you prepare before you ever step foot inside that courthouse. The single biggest mistake beginners make happens way before they even gather their receipts, and that is misnaming the defendant. You absolutely must identify the exact legal name of the person or business you're suing. For example, if you sue a fictitious business name like Mike's Painting and you actually win, well, you're likely going to end up with an uncollectible judgment because Mike's Painting doesn't legally exist. You've got to check the Ohio Secretary of State's website to find their actual corporate identity, something like Michael J. Smith, LLC. Sue the exact legal entity or you simply won't see a dime. All right, now for your physical evidence checklist. You need to gather up all your written contracts, invoices, printed text messages, printed emails, and printed photos of any damage. And here's a rock-solid rule for the courtroom. You must bring the original document plus 3 printed copies. That's 1 for the magistrate, 1 for the defendant, and 1 for yourself. And please, whatever you do, do not expect to just walk up and hand your smartphone to the judge so they can read a text message. That is 100% not acceptable in court. Print the whole shebang out. Okay, let's transition into Section 3, filing and serving process. This is the active stage of our journey, where you formally initiate the lawsuit and officially notify the defendant. First off, you're going to fill out a super simple complaint form at the clerk's office and pay the filing fee. Now, these fees do vary by county, but they are intentionally kept really low. The base filing fee generally ranges from about $25 to $75. And this amount usually covers the administrative costs plus the initial certified mail service for one defendant. If you need to sue an additional defendant, it might cost you another $5 to $15. Compared to standard civil court, this is a massive bargain.
But hey, what if you genuinely can't afford that $75? Well, reassuringly, the justice system is actually open to everyone. If those filing fees are just too burdensome right now, you can ask the court clerk for what's called an affidavit of indigency.
This is basically a sworn statement declaring that paying the court costs would cause you real financial hardship. If they approve it, the court will completely waive your filing fees so you can still seek justice.
Once you've filed, the defendant has to be formally notified of the lawsuit, a process legally called service. Now, you cannot just walk up and hand the papers to the defendant yourself. There are rigid rules here. Step 1 is the default. The court clerk sends the summons via certified mail. If the defendant signs for it, great, you're good. If they refuse it, then you move to Step 2, which involves paying a tiny fee to have a sheriff or a court bailiff personally serve them. If that somehow fails, Step 3 allows the court to just send it via ordinary mail.
Now, if you're sitting there worried this is going to drag on for years like you see on TV, don't be. Small claims cases in Ohio move incredibly fast. Once you file your claim on day 1, most courts are going to schedule your hearing within a 30 to 60-day window. It's a really rapid, streamlined process designed to get you a swift resolution.
Which brings us to Section 4, attending your court hearing. The big day has finally arrived, and it's time to present your dispute. Don't be intimidated, though. You have totally prepared for this.
So the crucial point is understanding your goal here. There are no juries in small claims court, just a magistrate or a judge. And unlike criminal court, you don't have to prove anything beyond a reasonable doubt. You only need to prove your case by a preponderance of the evidence, which is really just a fancy legal term meaning your side of the story is more likely to be true than not. If the scales tip even 51% in your favor based on your evidence, you win.
To make absolutely sure those scales tip your way, you need to command the room properly. Arrive early, dress respectfully, and speak directly to the magistrate. Never, ever bicker with the defendant. And crucially, if you're relying on, say, a mechanic to prove your car was damaged, they must be standing right there next to you in person. Written, notarized letters won't save you here. They simply aren't allowed as evidence. Finally, try to anticipate the defendant's counterarguments so you have your responses and your evidence ready to go.
Let's move on to our final act, Section 5, Post-Hearing Judgments and Appeals. So what actually happens after the magistrate bangs the gavel and the hearing is completely over? Well, first, usually you'll receive a magistrate's decision in the mail shortly after the hearing. If you lose and you truly believe the magistrate made a legal error, you have a very strict 14-day window to file specific written objections and pay an objection fee. If you miss that deadline, the judge is just going to formally adopt the magistrate's decision and it becomes a final judgment.
Now, what's really interesting about this slide is the reality of winning. Getting the judgment does not mean the court just writes you a check on the spot. No, it is entirely up to you to collect your money. If the defendant flat out refuses to pay, you have to actively collect using the court's tools. Step 1, you can file for wage garnishment to pull money directly from their paycheck. Step 2, you can file an attachment on their bank accounts. Or Step 3, you can even place a judgment lien against their real estate.
Sure, it takes a little bit of legwork, but these are incredibly powerful tools. So are you ready to take back the money you're owed? Small Claims Court is your highly accessible path to justice. It completely empowers you to represent yourself, hold people accountable, and resolve your financial disputes without breaking the bank on legal fees. And finally, before we wrap up today, I do need to state that the information provided in this explainer is for educational and informational purposes only and does not constitute formal legal advice. Please be sure to consult with a licensed attorney for specific legal concerns or complex cases. Thanks so much for joining me, and good luck out there.